Hi, this is Dwight Pettit. I want to take this opportunity to talk to you today about the criminal process. Criminal process can be very involved and very complicated, and it helps to understand the procedure and how the process works when you're considering the lawyer, the representation, and what you're about to embark on. The first process in terms of the criminal procedure is whether or not the case is a felony or in fact a misdemeanor. One or the other, they take different directions. So let's talk about the misdemeanor first. The misdemeanor is something that's usually in the state of Maryland is handled in our state district courts. And that's usually something involving those type of potential prison sentences which are the lesser sentences as compared to felonies. You will get a trial date in the district court, and usually bail is reasonable, but that's something that we'll discuss at a later time. And your trial date is usually within 30 days of the time that you're charged in a misdemeanor now. And so in Baltimore City, those trials will take place in Wabash, they take place at North Avenue, they take place in the counties, they take place at Walker Avenue, they take place in Towson and other locations. But in those areas, you have the opportunity to retain counsel, and you should retain counsel to be with you to protect your rights in terms of the district court. And of course, then there are the felony charges. The felony charges are things which involve the more serious charges against an individual, things that can deprive you of liberty for quite some time, and in the state of Maryland, unfortunately, as that may be, still the death penalty. And in those cases, you are arrested and you have the opportunity for a preliminary hearing. And this is very important, especially in some jurisdictions. In Baltimore City, your preliminary hearing is determined by the state's attorney's office as to whether or not they're going to indict or whether or not you can in fact have a preliminary hearing. But in the counties, particularly Baltimore County, you have to request at the time you see a commissioner and he's determining, or he or she is determining your bail, you have to request a preliminary hearing. If you don't request that preliminary hearing is waived. And at the preliminary hearing, which is approximately 30 days from the date that you are arrested, that preliminary hearing will determine whether or not there was probable cause to in fact bring the charges against you. And something else that a lot of people don't realize, one of the important things about the preliminary hearing is that in most cases a judge will allow you to in fact raise the bail issue again in terms of whatever bail was set by the commissioner and the initial judge setting the bail, in many cases because the district court still has jurisdiction. At the preliminary hearing, you can argue, or through your lawyer, argue the bail all over again if you've been given an unreasonable bail. And so the preliminary hearing can be very important to establish whether or not there was probable cause. Number two, to find out more facts about your case. And number three, to probably resurrect the bail issue if you've received an unreasonable bail. But you need a lawyer for these important steps, and whether misdemeanor or whether preliminary, you need a lawyer. And so give us a call, Dwight Pettit at dwightpettitlaw.com, Dwight Pettit 410-542-5400.